Pardon to the translators. Did not mean to make you jump that much. Welcome here, everyone. This is meeting number 53 of the Standing Committee on Public Safety and National Security, Thursday, February 10th, 2011. Today we will be continuing our study of Bill C-17, an act to amend the Criminal Code, investigative hearing and recognizance with conditions. Members will recount that the Minister of Justice, the Honourable Rob Nicholson, and his officials testified before our committee on December 15, 2010, outlining the goals and the features of this bill. Appearing before us today, we have from the Canadian Muslim Lawyer Association, Ziad Mia, Chair of the Advocacy and Research Committee. Welcome. From the British Columbia Civil Liberties Association, Carmen Chung, Counsel. As well, we have from the Canadian Jewish Congress, Eric Vernon, Director of Government Relations and International Affairs. We thank you for coming, and actually only on an invitation that came yesterday, so thank you very much. And from the Canadian Civil Liberties Association, Nathalie Desrosiers, General Counsel, and again, much the same there. Thank you for coming on short notice. Our committee thanks the panel for agreeing and making the effort to appear before us today. And I understand that each of you have opening comments, and then we will proceed into a number of rounds. We have the 2 hours today, or just short of that. We'll proceed into 2 rounds of questions. So perhaps we can just work our way, maybe starting from the left to the right. Mr. Mia.
Thank you, Mr. Chair. Good morning, Mr. Chair, members of the committee, fellow witnesses and guests. My name is Ziad Mia, and I am representing the Canadian Muslim Lawyers Association today. Thank you for inviting me to participate in this session on this very important matter that we have before us. The Canadian Muslim Lawyers Association represents various Muslim lawyers across this country, and as some of you may know, we've been involved on the national security, anti-terrorism issues that have arisen over the last decade quite deeply. And we have a number of concerns, and we've expressed them over the last 10 years. Some of them heard, some of them not heard. And hopefully you will listen to us today, and we can engage in a discussion about our concerns. One of our central concerns with this legislation and the general tone of law and policy in this area is that it is largely driven by fear. And the problem with that is fear does not develop good law, it does not develop good policy. And at the end of the day, in this climate that we have in the world, in the war on terror, the culture of fear, unfortunately, in the world we're in now, and the climate, there's xenophobia. Muslim Canadians, Muslims around the world, seem to be on the brunt of it. That's not the essence of all I'm going to talk to you about today. That is one concern I have. I also have concerns about having broad and blunt powers that are not precisely crafted, put into the law, that sit there and may be used against other vulnerable and minority communities in the future. And at the end of the day, when you have poorly drafted laws, mistakes are made, and innocent people's lives are destroyed. And that's a real thing. I mean, we read about it in the papers, but at the end of the day, when the rubber hits the road, it's real people, real children and families that are destroyed, and you can't put that back together through compensation alone. So at the end of the day, we have two major concerns, that these laws that are before you today are not necessary. We have in this country a criminal code which is robust. There are a number of provisions, and I'm happy to engage you on them, but what we have before you today is legislation that takes us away from the fundamental protections in the criminal code and the Constitution of this country, and that are finely crafted to strike the right balance in respecting rights and getting at criminals and terrorists, because that's what terrorists essentially are. And we're watering down, or in some cases possibly throwing away, historic fundamental protections that have been with us for centuries on arbitrary detention, habeas corpus, judicial independence, and the separation of powers. These are not things that are taken lightly, and we are putting them significantly at risk. My second point is that these types of powers run the risk of abuse. And when we talk about it today, we can talk about all the examples we now have over the last 10 years of the mistakes that have been made and innocent people's lives that have been destroyed. I don't think that's your aim, and I don't think that's our aim at the Muslim Lawyers Association. We stand firmly with every other Canadian to stop terrorism in its tracks, but we need to make sure we don't catch a lot of innocent people in the process of doing that. It'll stigmatize some communities, and as I said, there is the very real fear of scope creep once we start to change the fundamental fabric of the legislation and the Constitution of this country. Many people have come before your committee, and the rhetoric and the discourse is about striking a balance between national security and civil rights. I'll tell you one thing, I don't think we need to strike a balance. The fact that we have a constitution in this country and the criminal law in this country, a balance has been struck. We don't have a system of absolute rights. Section 1 of the Charter is essentially a balancing mechanism. We, as a community, have decided to strike that balance. What you're doing is moving that balance from here to here, closer to security. And that is fine if you want to do that. But I don't think that's being discussed exactly in that way. We've been told we're balancing things from absolute to a balance, when in fact what we have is a movement of that balance. We're moving and altering the fundamental social contract in this country, and we're not having a proper public debate about it. So that is a fallacious argument to say that we're striking a balance. As we've said, our position before you on numerous occasions in front of other committees is that these provisions are unnecessary. And the fundamental principle of legal drafting is you do not draft laws that are unnecessary, and you need to be precise in drafting. We have, and we can talk about them, and you've heard about them before, the Criminal Code. Section 495 of the Code allows you to preempt criminal activity. It was fallacious for the previous government and for those now to say that we need to stop the terrorists before they get on the plane, and that we didn't have the tools to do that before. We did have the tools to do that before. It was called the Criminal Code and investigative techniques. So we need to use those. I agree, we need to use those robustly. But to say that preventative arrest is needed because we need to stop something that might happen, well, we have tools that will do that. The peace bond measures. Section 810 of the Criminal Code, as you know and as you've heard, have those protections already there, including for terrorism. Now, I may have some critiques about how those may be applied broadly in a civil liberties perspective, but those are there, and they're based on reasonable grounds, not reasonable suspicion. That's a very important point we should be talking about today. And Part 13 of the Code covers all sorts of preparatory offenses, conspiracies, attempts, etc. And those address exactly what prevention is all about. So basically what I think we're doing today as a society is putting the cart before the horse. These are poorly designed laws. They're overly broad, they're loose, And they're giving police and the security agencies, although CSIS doesn't use these powers, their investigations lead into this, they feed into this system. We're giving them loose, blunt powers, and they're ill-equipped to deal with them. You know, there's a host of inquiries that are sitting on the table, gathering dust. The Arar inquiry, the Area India inquiry, the Yakabuchi inquiry. You have two cases where the CSIS and the RCMP were roundly thrashed in Almarai and Sharkawi. Roundly thrashed to being incompetent, not really understanding geopolitics in the real way that it should, so we can catch real terrorists. Instead, they're wasting resources on other things. That's what we heard from Justice Mosley. And you have, on top of that, forget national security. The RCMP is in a bit of disarray. You have the Jakansky affair, which is a tragedy, a fundamental tragedy in this country. That innocent man was killed, and then the RCMP moved forward to mislead all of us. Not only is it an insult to our intelligence, it is fundamentally wrong. So there's a lot that's wrong with the RCMP. Just on this table 2 days ago, you heard about the problems from the RCMP senior brass about what's wrong with the RCMP. We know that CSIS doesn't get it, as Justice Mosley says. They don't understand what jihad is. They had it all wrong with Almarai in the first case. So they're chasing an innocent guy when they should be chasing real terrorists, putting the cart before the horse. What you need to do is clean house with CSIS and the RCMP, implement the Arar Commission findings immediately, have that oversight, that transparency, those protections, so we get our police and security agencies going after real terrorists, which is what we all want to do, while respecting the rule of law. So essentially we have a picture of a security service and a national police force that's dysfunctional and in disarray, and you need to work with them to clean that house before we even consider any extraordinary new powers. You know, these are sunsetted provisions, which you're trying to bring back, and the point of a sunsetted provision is exceptional power. Now, if we keep renewing this, it's not an exceptional power anymore. Justice Binney, in the Air India case that looked at the investigative hearings, raised that very concern, that at the end of the day, if you keep renewing, he raised this red flag that you keep renewing this, it is no longer an exceptional power. And from a rule of law and a democratic perspective, that is very dangerous. We are now at the point where we might have permanent emergency legislation, permanent exceptional legislation. I don't want to get into constitutional theory, but it's fundamentally contradictory to our system of government and the rule of law. That is the kind of thing you see. Mr. Mubarak has 30 years of emergency law. It's a bit absurd. It's a permanent emergency. This is what, and I'm not comparing us to Mubarak or the Nazis. Obviously, we're far from that. But I'm raising the issue because we don't want to start adopting measures that are indicative of those societies. Nazi Germany had legal theorists that said essentially that the leader decides when there's exception and when it ends. We don't have that. We have the rule of law, and we have oversight over government. We have courts, checks and balances, and we have oversight over police and security services. And I'm telling you, we don't need to make, we'll just pass this another 5 years. We need it, because security agencies will always tell you they need more power. Every government agency and every institution will tell you they need more power and they need more money. That is just how things work. So I'll leave you with one reminder. I'm finishing up. I'm sure you're all familiar with Edmund Burke, a great parliamentarian. And over 200 years ago, he said, and he was actually the father of modern conservatism, I have a lot of respect for him, that the true danger is when liberty is nibbled away for expedience and by parts. And I think that is what we have before us today, that we're nibbling away by expedience. Let this one pass, let that one pass. At the end of the day, we have nothing left. So thank you very much for your attention, and I look forward to your questions.
Thank you, Mr. Mia. We'll now move to Ms. Chung. 10 minutes.
Thank you very much. Good morning. My name is Carmen Chung, and I'm counsel with the British Columbia Civil Liberties Association. On behalf of the BCCLA, I wish to thank the members of the committee for the invitation and opportunity to present on Bill C-17 today. The BCCLA is a nonprofit, nonpartisan advocacy group based in Vancouver, British Columbia. Since its incorporation in 1963, the mandate of the BCCLA has been to promote, defend, sustain, and extend civil liberties and human rights around Canada. We speak out on the principles which promote individual rights and freedoms, including due process and fundamental justice concerns in situations where individual interests are affected or engaged by the state. In December, this committee heard from our colleagues with the International Civil Liberties Monitoring Group, La Ligue, the Canadian Council on American Islamic Relations, and others, and the BCCLA echoes many of the concerns so persuasively voiced here already, namely that the proposed legislation does little to protect Canadians, while at the same time compromising many precious and hard-won democratic safeguards. Let me start off by addressing the preventative detention provision, which permits a holding of an individual without charge for up to 72 hours based on mere suspicion of dangerousness. When this provision was last enforced in the Criminal Code, it was never invoked. Advocates for preventative detention point to this statistic as demonstrating restraint on the part of law enforcement agencies. We view this as evidence that such sweeping powers of preventative detention are simply unnecessary. Protection of personal liberty is a fundamental value in Canadian society, and indeed in any free society. Expanding the powers of the executive to detain people must be examined with the utmost scrutiny. Canadian principles of fundamental justice impose limits, both procedural and substantive, on deprivations of liberty. This means two things. First, the process through which any individual is subjected to detention must meet the requirements of fundamental justice. Second, the substantive reasons for any detention must be justifiable in a free and democratic society. Detention without charge or conviction is deeply problematic because it is based on a hypothetical. It depends upon speculating on the future dangerousness of an individual because of an assumed propensity. Preventative detention is necessarily based on propensity reasoning because if there was actual evidence of preparation to commit a terrorist act, of conspiracy to commit a terrorist act, then there would be grounds to lay charges for committing a criminal offense, and suspected individuals could be detained under the usual criminal law procedures. Stripping an individual's liberty where no offense has been found to have been committed, or where no offense is even suspected to have been committed, runs counter to basic principles of fundamental justice. The Criminal Code, as it currently exists, contains more than adequate mechanisms for prosecuting past terrorism offenses and preventing future ones. The sweep of terrorism-related offenses in the Criminal Code is broad. As defined in the Code, terrorist activity encompasses everything from conspiracy to the attempt or threat to commit an act of terrorism to the actual terrorist act itself. The Code also confers expansive powers on authorities to impose conditions on individuals who pose a danger to public safety. As you've already heard, this is reflected generally in Section 810.2 and with respect to terrorism offenses in Section 810.01. And as you've also already heard, as recent law enforcement investigations have shown, the terrorism provisions in the current criminal code are effective. They have been successfully used to protect the safety of Canadians and to disrupt prospective terrorist attacks. Detaining individuals based on predictions of future dangerousness is a troubling proposition. Because the requirements of proof are relaxed, there is an increased chance not only of error or abuse, but of such errors or abuse going undetected and without remedy. For example, it may be difficult to accurately assess whether the prediction of dangerousness is ultimately borne out. Let's say an individual is held in preventative detention and no terrorist attack takes place. The fact that no terrorist attack ensued may mean that by detaining the individual, law enforcement officials successfully disrupted the terrorist plot. But it may equally mean that the detained individual was not involved in any planned attack at all. Such uncertainties cannot be the basis on which Canadians or others in this country are imprisoned for any length of time. On the other hand, prosecuting inchoate offenses such as conspiracy permits the government to incapacitate potentially dangerous people and disrupt terrorist plots before they can take place. But the evidentiary requirements for laying charges provides a measure of protection against mistake or abuse. Separate from the deprivation of liberty associated with preventative detention, there is the stigmatizing effect of being labeled a terrorism suspect or an individual associated with terrorist activities. We believe that it is fairly uncontroversial to say that the stigma associated to an accusation of terrorism is severe. Yet the system of preventative detention proposed in this bill would effectively brand an individual as a terrorist, even though law enforcement officials may not have any grounds to lay charges, let alone evidence to convict, now or ever. the potential harm to that individual's reputation, and other negative impacts flowing from being labeled as a terrorist cannot be discounted. With respect to the second substantive prong of Bill C-17, the reintroduction of investigative hearings, we would observe that such a mechanism effectively renders the courts an investigative tool of CSIS and the RCMP. Indeed, we would adopt the logic of Justices LaBelle and Fish of the Supreme Court of Canada, where they found that investigative hearings, such as the ones proposed here, compromise judicial independence from the other branches of government, which is a cornerstone of our democracy. Although writing for the dissent, Justice LaBelle and Justice Fish's words should have resonance for anyone who subscribes to the concepts of the rule of law and the independent judiciary. They wrote, "Although a judge may be independent in fact and act with the utmost impartiality, judicial independence will not exist if the court of which he or she is a member is not independent of the other branches of government on an institutional level." Section 83.28 requires judges to preside over police investigations, and as such investigations are the responsibility of the executive branch. This cannot but leave a reasonable, well-informed person of the impression that judges have become the allies of the executive branch. And while the previous iteration of this investigative hearing provision may have been deemed, quote, charter-proof, to borrow a phrase from Professor Kent Roach, that does not mean that these measures are truly compatible with the right against self-incrimination. As contemplated by Bill C-17, investigative hearings bear all the hallmarks of complying with the right against self-incrimination. We would submit, however, that they still do not comply with the spirit of the right to silence. We believe that Professor Roach of the University of Toronto Law School perhaps said it best with respect to the 2001 version of this provision. Regardless of whether investigative hearings can or cannot survive charter review, he wrote, there is a strong case that they are unnecessary, unprincipled, and unwise. Those who will talk will do so without the threat of prosecution. Those who will refuse to talk or who lie will likely not be deterred by the threat of continued detention or prosecution for failing to obey a judicial order or for perjury. More fundamentally, it is unworthy to abrogate centuries of respect for the right to silence and the right against self-incrimination during police investigations. Attempts at charter-proofing in the form of judicial authorization, right to counsel, and use and derivative use immunity should not take away from the fundamental damage that investigative hearings will do to our long traditions of adversarial criminal justice. And indeed, while the Supreme Court did find the 2001 investigative hearing provisions to be constitutional, it made that finding only reading into the law what had not been expressly provided by Parliament. It placed limits on the use of investigative hearings. Specifically, it held that information gathered could not be used against an individual in any kind of proceeding, including extradition or deportation hearings or proceedings in foreign jurisdictions. As it is currently drafted, however, the investigative hearing provision fails to reflect those requirements and leaves open room for potential misapplication of the law. Given the danger that the information compelled through investigative hearings could potentially be used against Canadians or others abroad, perhaps by countries where human rights protections are not as robust as those found in Canada, we are deeply concerned that the Supreme Court's direction has not been codified here. Finally, we wish to note that while the provisions at issue here, like their predecessors from 2001, are accompanied by sunset clauses, we fear that putting these measures in law again will be far from temporary. We urge you to refrain from passing this legislation and giving it a state of de facto permanence in Canada. Canada has historically served as an example among nations of how democracy, freedom, and rule of law can be upheld on an ongoing basis. But we must be vigilant in protecting these values. The measures proposed by this bill have afforded no demonstrable gains in combating terrorism, and instead work to erode the democratic principles and ideals that we seek to protect. I'll end here for now. Thank you again.
Thank you, Ms. Chung, and we'll now move to Mr. Vernon, please.
Well, thank you very much, Mr. Chair, and thank you for the opportunity, even as late in the day as it came, to appear before this committee as it studies this important legislation. I'm delighted to be here on behalf of Canadian Jewish Congress, which for over 90 years now has been the advocacy voice of the Jewish community of Canada and a voice for human rights for all Canadians. Je vous remercie pour l'invitation.
I thank you for this invitation. to share with you the opinion of the Jewish Committee on the Anti-Terrorism Fight in Canada and Bill C-17.
That Canadian Jewish Congress supports Bill C-17. And I think it's good that I understand what it means to be a minority, because I clearly am one at this panel. At the same time, we would examine with interest any amendments that this committee might eventually recommend after completing its review towards strengthening the legislation as part of the overall anti-terrorist regime in Canada. It will come as no surprise, I'm sure, that Canadian Jewish Congress has for many years, and well prior to 9/11, been a strong advocate for a comprehensive and effective counterterrorism regime in Canada on behalf of a community that is essentially twice targeted, that is, both as Canadians and as Jews. In our brief on the legislation establishing CSIS, the Canadian Security and Intelligence Service, CJC noted, and I quote, "If terrorism is allowed to implant itself in Canada because we are reluctant to establish realistic measures to prevent it, its impact will spread beyond any particular community to affect Canada as a nation and in the international forum. As terrorism grows more organized and more international in scope, so must the efforts to contain it be more organized, serious, and efficacious." Members of the committee, that brief was submitted in April 1984, almost 27 years ago. And yet, in the aftermath of September 11th, it became clear just how unprepared Canada was in dealing with the threat of international terrorism and its domestic manifestations. Canadian Jewish Congress was therefore gratified by the government's introduction of then Bill C-36, including the two ultimately sunsetted clauses which lie at the heart of Bill C-17 now. To date, thankfully, Canada has been spared the agony of the suicide bombings and attacks that, at least since the turn of the new century, have become a commonplace weapon in the terrorist arsenal. But our nation has certainly not been immune to terrorism, not least the tragic events surrounding the bombing of Air India Flight 182. Canada's Jewish community has been targeted for terrorist violence by the likes of Ahmed Rassam and Jamal Akal, and beyond that, we cannot but see the community's security in the context of the vulnerability of and attacks on sister communities elsewhere in the world, both before and after September 11, 2001. Given the multicultural and pluralistic nature of its society, Canada is especially vulnerable in an increasingly interconnected world to terrorist infiltration. While the vast majority of ethnic, cultural, and community groups and their members pose no threat, terrorists are well positioned to exploit, intimidate, or attract individual fellow ethnics and or co-religionists into supporting, financially and otherwise, and providing valuable cover for their activities in one way or another. We have already had a glimpse into the potential for homegrown radicalization, and if that weren't enough, we have the examples of the UK and elsewhere in Europe to ponder. From our perspective, it was a decided strength of the Anti-Terrorism Act that it set its primary sights on prevention of terrorist acts rather than the apprehension and punishment of perpetrators. Potential terrorist operations, or those discovered in progress, must be thwarted immediately. The powers of recognizance with conditions and investigative hearings introduced by the Act remain important for the attainment of this purpose. Though having been sparingly used, as we know, it is still important to have these powers available to our security and police forces. Because the best and first line of defense against terrorism is effective and timely surveillance and intelligence gathering, intrusive though they may be at times. We believed in 2001 and continue to believe in the importance of granting expanded powers to the security services through recognizance with conditions and investigative hearings for the careful monitoring of individuals and groups that are suspect, and the amassing of relevant information well in advance. Now, since the passage of the Anti-Terrorism Act, Canadians have been passing judgment on how well it met the most fundamental challenge facing any democracy, namely, how to provide for the safety and security of its citizens while minimally impairing the basic civil liberties that underpin their society. The two sunsetted measures clearly provide a stern test to any democratic society. In fact, these two provisions seem to epitomize the zero-sum game of protection of security versus protection of human rights. And as we know, they ultimately died on the floor of the House of Commons. From our perspective, one need not approach the debate from the either-or perspective of security versus rights. If terrorism is rightly regarded as an assault on human rights, it stands to reason that the implementation of counterterrorism measures necessarily protects the highest priority rights of life, liberty, and the security of the person, the foundation of all other rights and freedoms. Now, the corollary, of course, is that these actions themselves must always be rooted in and comport with the rule of law. A properly framed and implemented counterterrorism policy enhances civil liberties and core charter values and protects them as part of the way of our life, whose essence is threatened by terrorism. A look around the world clearly tells us that terrorist acts remain a clear and present danger, and our security and police personnel must have sufficient authority to take preventive action to interdict possible attacks before they occur. Nonetheless, we are fully cognizant of the potential severity of these measures, and we are heartened that Bill C-17 provides additional safeguards to reassure Canadians concerned about the possible adverse impact of these measures. Members of the committee, the most fundamental role of the state is to protect the safety and security of its citizens and the core national way of life. Governments such as ours must thwart the efforts of those who would use our open society against us and then shut it down, while at the same time we must be sure not to impair the very democratic nature of that society. But it would be the ultimate irony if in striving to maintain civil liberties, we strip authorities of the necessary powers to stop terrorists and extremists from destroying our open and free society. In our respectful submission, Bill C-17 deserves expeditious passage as it successfully meets the challenge in restoring the authority for the use of recognizance with conditions and investigative hearings while providing additional safeguards for fundamental civil liberties and rights. I thank you for your kind attention and look forward to your questions.
Thank you very much, Mr. Vernon, and we'll now move to Ms. Desrosiers, and welcome back.
Okay. Merci beaucoup. Je remercie.
Thank you very much. I thank the committee for having invited the Canadian Civil Liberties Association to present. I'll be starting in French, and then I will be moving to English. Our association has been in existence since 1964. We've always been advocating for the rights and liberties of Canadians. We will have 4 suggestions in the context of our submissions. First of all, the Bill C-17 as presented contains some serious flaws that need to be corrected. Second, like other groups that advocate for human rights and freedoms, we raise the issue of the need to proceed in this way and to pass this bill as presented. And finally, I won't repeat or reiterate what was said by my colleagues. Simply, I'd like to say that there is an international context within which this bill would fit. And I'll start with that. Of course, in this context, we can take a sober look at provisions that were implemented in 2001 that died through the sunset nature of these provisions in 2007, and now we have an opportunity to look at them again and see whether they were appropriate and needed. This is in the context where we see that the UK in the same context is considering reviewing the control orders which had been used as of 2001. One of the reasons why several people have said Bill C-17 is not that dangerous is because it has not been overused by our police forces. Yet it creates a precedent within international law. It becomes a precedent for other nations throughout the world so as to use Canadian precedent in this sense. The only guarantee Canadians have had through these powers is that they were not abused, in fact, that they were practically not used. the same would not apply in other countries, and I think it's important in the context of a leadership role for Canada internationally on human rights to ask ourselves whether now is the right time to move forward with this type of legal measure. And I think this will be one of our proposals, something that here is looking at some of the organizational values of within our system.
Wanted to make outside of the context, the international context that should be looked at, is the context in which I think that has been said, but I won't repeat what my colleagues have said. I just want to stress a couple ways in which the bill stresses our system in its fundamental tenets. There are three tenets, I think, of our system that are at odds with the premise and the economy of the bill, and I think that's why we are searching within this bill for guarantees as civil libertarians. The first one is obviously that we live in a system where the judges are not inquisitorial judges. They are judges that are trained, that work in a context of contradictory evidence. And indeed, I think one of the ways in which we have been able to fine-tune our system of counterterrorism, which the Canadian civil liberties, like us, support the idea that the government has the duty to engage in counterterrorism. What we're debating here is whether this is the best way. It's not to question the effort, it's to ensure that indeed it does what it seeks to do. In this context here, the way in which we have responded in other contexts is to insist that they be special advocates, to ensure that the judges are not put in a position to be inquisitorial. They're not trained for this. That is incompatible with the way in which they are proceeding. And this is not present here. You know, contrary to what has happened in after the Sharkawi decision, we are not seeing here a recognition that there needs to be, if you're going to put someone and threaten his or her liberty in front of a judge in a context where the judge will have to rely on the information provided, you need to balance this by having at least a special advocate. I mean, that's what we've learned in other contexts, and I think this indeed should be looked at in this context as well. The second tenet of our system, I think that is fundamentally challenged by Bill 17 is the one that has been referred to earlier. It's the fundamental tenet that you ought not to be detained, you ought not to be arrested, you ought not to be subject to punishment unless there is a format, a framework by which the accusations against you can be tested and there's an end to the process. There's evidence on which you can be tested, and then at the end of the day they are tested, and either you are found to be guilty or not, and that's the end of it. This process allows preventative detentions which threaten that very concept that comes from the strong protection of habeas corpus. I mean, it creates a fracture in our legal thinking, and that's why people react to this with such visceral fear, is because it took many, it was a great advancement in law and legal thinking to insist that the king not be able to put people in jail simply on the basis that he, being the king, was afraid that something might happen that might threaten the order of the public. The writ of habeas corpus was a great advancement in saying it is inappropriate to detain people without having a process to fundamentally challenge the evidence on which they are being detained. And in this case, that's why people react with such fear to this way in which preventative detentions are being put as normalized in the process. And finally, I think the third principle of our system, and there's no obligation on Canadians to cooperate with the police. Here they are forced to come and give testimonies in front of a judge I think, as Kent Roach has said numerous times, some people will tell the truth, some people will lie, and indeed we will have no ability to, it's not going to be that much, they will not cooperate more because there's a threat of being incarcerated. Now let me go through the different disposition and look specifically at some of the challenges that they present and some of the ways in which they ought to be. In our view, the bill should not proceed. It's not necessary, and it's not the way to go. But if it is to proceed, it must have additional guarantees that are not there. The first one is, I think, under Section 83.28. There is no guarantee that that this indeed will not be relying on evidence obtained under torture. That's a significant issue. What we would suggest is that there be a specific reference, a commitment, that there be in there a reference saying that there is an affidavit from CSIS, there's an affidavit from the police, and that is being recognized by the judge as though the evidence has not been obtained under torture. And we're insisting on this not only because there is a general prohibition around the world against torture, and Canada should be part of it, should be an instrument, a motor on this. It's a good signal to say to other countries that indeed whatever evidence they would want to lead in will not be acceptable. But what's interesting as well is that it protects our system from being polluted by the fact that some evidence obtained under torture may have found its way somewhere. If everybody along the system has to guarantee that to the best to their knowledge, and they do the investigation, the evidence has not been obtained under the torture, we improve the guarantee that the system will not inadvertently have be an instrument of perpetrating of torture. I think that one of the concerns that has been raised, and I think my colleague has raised it, is that it does not protect the testimony from being used not in proceedings outside of Canada. This was mentioned by the Supreme Court. This is not in the bill. It should be in the bill, and it should not be used as well against members of the family of people that testify. That's another aspect. Many people that could be compelled here will be shunned for sure by their community, but expose themselves to great dangers, and there's no provision here to ensure their protection. I will just, I know my time is running out, and I just want to make sure that, so no special counsel proceeding has been, there has been no guarantee that no evidence has been obtained under torture. There's no boundaries to the conditions that can be imposed by the judge. And indeed, I think there should be a way in which these conditions are being reviewed and are not unnecessary. And finally, there's no right of appeal. There should be a right of appeal.
Thank you very much. To all our witnesses. We'll move into our first round of questioning. Mr. Holland, 7 minutes, please.
Thank you, Mr. Chair, and thank you to the witnesses, each of you, for very compelling testimony. I think we recognize that the initial clauses came into being immediately after September 11th. At that time, there was a feeling that we needed to act as quickly as possible to do something, to give extra powers to police. But I think wisely those provisions had sunset clauses to allow the country, both the Parliament, Canadians, and the judiciary to examine both the necessity and the applicability of those provisions. Over that period of time, we, as the witnesses have said, have heard from the Supreme Court. We have also heard from the former head of CSIS, who says that these provisions are unnecessary and don't provide any additional security. But I have to say that I've also been moved by seeing the faces of security and intelligence failures. Mayor Arar, Mr. El-Mahdi, Mr. Nuruddin, Mr. El-Melki, and others. A couple of other cases that were referenced as well by Mr. Mia. And what concerns me, well, before I go to that point, let me just say to Mr. Vernon, I have to reject the premise that the suspension of due process or civil liberties for the possibility of greater collective security is unto itself not enough, because the danger of that argument is it has no end. That argument could continue to a point where it fundamentally destroys I think the things that are most fundamental and important about what we're trying to protect. So the question here is, if you are going to suspend the civil liberties of an individual, if you are going to suspend due process, can you demonstrably prove two things? One, that you are actually, in fact, making substantive improvements to collective security. And the second is, do you have vigorous and robust oversight to ensure in those circumstances that, the power will not be misused, or that the powers will be restrained, or that if mistakes happen, that they will be immediately caught and rectified. On the first point, I am yet to hear in the testimony that we've had over the three meetings that we've had any specific concrete examples of specifically how these provisions would achieve my first point. In fact, we've heard from the former director of CSIS, who is responsible for oversight of all intelligence services in this country, not say before this committee, but say publicly, that these provisions fail in that first measure. The second one, and this is one is, I think, even more important, and I would bring this question first to Mr. Vernon. The second one deals with oversight. We have O'Connor, Iacobucci, Brown, Public Safety and National Security Committee, Mr. Kennedy, Mr. Major, all of whom have brought out recommendations on oversight, the vast majority of which are unanswered. We have many departments involved in intelligence today that have no oversight. Immigration, as an example, the Canadian Border Services Agency, as an example. Would you not agree with me, Mr. Vernon, that prior to the continuation or the reinstitution of any extraordinary measures, that we would first have to make sure that security and intelligence oversights, failures and deficiencies that exist today must be repaired?
Well, thank you for your questions, Mr. Holland. I think that it would certainly be in the best interests of the country to have those recommendations examined carefully and the ones that would be effective to be implemented. But I don't see that as a necessary first step toward maintaining these powers. We're not talking about powers that have been exploited or abused at all. This notion that these powers are some kind of first step down the slippery slope to fascism or some kind of jackbooted changes in our fundamental way of life, I don't think hold water. So I don't think that the changes that are being recommended here in this bill need to be held hostage to the implementation of recommendations of other
I guess
inquiries.
my point, though, Mr. Vernon, is these are not examples in abstraction. These are very specific examples. I've given you very specific names: Canadians who found themselves detained and tortured in foreign jurisdictions, according to Canadian inquiries that said it was the failures of Canadian intelligence and security that led to their detention and torture. Those individuals faced horrific circumstances as a result of failures here in Canada and because of a lack of oversight that was in place in this country. And so I'm saying to you, not in some vague abstraction, but with great specificity, should we not ensure that we fix those deficiencies before giving or even contemplating expanded extraordinary powers that would have the potential, if there is not vigorous and robust oversight, to have other such failures?
I think the second part of your formulation is probably something that we'd be more sympathetic toward. I mean, obviously, the impact on the lives of the individuals you've mentioned is not something that we take lightly. But it seems to me that having these powers in place do not necessarily mean that they're going to be improperly used or that they represent some kind of thin edge of the wedge of the destruction of our democratic way of life. If you have some specific proposals that will enhance parliamentary oversight, I think that would be very important. We'd certainly be interested in looking at those. Obviously, our police and security services are made up of human beings. There are mistakes, there are flaws. But the systems are in place. There are additional safeguards placed into this bill. If you have a couple of more or one or two key recommendations, we'd be happy to look at those.
And I know I have a very limited amount of time, but I would like to hear from one or some of the other witnesses on this point, because I think the issue of oversight is an important one. I agree with Mr. Vernon. People are human. Failures happen. And it's the reason why we need to have vigorous and robust oversight. In my estimation, for the reasons that I outlined, I don't feel it's present. And I'm wondering if I could hear maybe perhaps from some of the other witnesses on the import of that. Mr. Mia.
Thank you for your question. And
Mr. Mia, we're already a minute over, so
okay.
Very quickly.
I mean, when I talked about the balance, just to address your first question, due process and the adversarial process sets that balance to find the truth, to avoid mistakes while catching criminals. And to Mr. Vernon's point, I mean, this isn't an issue about parliamentary oversight, sir. This is really, our inquiry identified massive failures in the security and intelligence policing, CSIS, the RCMP, others, massive failures that led to the destruction of a human being, a Canadian's life, and because not everybody makes mistakes, and that is why we need oversight. And he didn't recommend pitches and patches. He recommended a robust oversight system that covered all security agencies, because if we're going to play in this game of national security and terror in the world, we better have a check and balance, and that's what he's talking about.
Thank you, Mr. Mia. We'll now move to Madame Morani, please.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Welcome to all our witnesses and thank you for being here. I have a question for Ms. Chung. You come from BC, so you must have followed the Mr. Fadden saga when he told the media that there were agents of influence, for one, in BC, and that perhaps there were municipally elected officials who were agents of influence of China. They're not going to cut me off now?
Mr. Chair, you'll note from today's agenda that the order for the day is to examine Bill C-17. I am not even remotely convinced that this line of questioning could in any way, shape, or form fall under an inquiry with respect to C-17.
Thank you, Mr. Athgaber. And again, I try to give as much latitude as I can to the line of questioning, but I'll tell you, relevance is something that we do try to, especially on these legislation, on legislation, to keep. So I would ask you to be relevant to C-17 and to the idea of terrorism, and I'll give you some latitude. So continue, Ms. Morani.
Monsieur le Président, si Monsieur me laissait...
Mr. Chairman, if the gentleman would allow me to finish, he would understand the relevance of what I'm saying. And second, I hope it won't be discounted from my time.
Thank you. Donc,
So, as I was saying, Mr. Fadden spoke to the media, saying that there were agents of influence in BC elected officials. I'm sure you followed the issue closely. I would like to know from you, this type of agency, directed by this type of individual, do you think this type of agency should be given further powers?
I'm not sure if that's precisely what's at issue here. Certainly, I think that CSIS has an important function in this society and in protecting Canadians. It is deeply troubling, the accusations that were made by Mr. Fadden with respect to potential foreign influences from the Chinese community or Chinese people, and so that is troubling. But what we are concerned about is really whether these powers are even strictly necessary. It's not so much the issue should be they given to CSIS or RCMP or whoever, but whether these powers are just necessary at all.
Vous parliez tout à l'heure.
Earlier on, you were talking about discrimination, and that's my point. Mr. Mia, perhaps you could answer this question as well. Regarding discrimination, I heard, at least in Montreal, and it might be the case throughout the rest of the country, you could tell me if this type of situation actually occurs, young Muslims are being harassed by CSIS, apparently, through some kinds of investigations, or they would go to these young people's houses, leave a card with their first name on it, and I'm concerned about this type of bill. It's giving even further powers to this type of organization that already has a fair bit of power, and certainly I've heard it from these young Muslim men that told me that they were not told what of their rights. They didn't know what they were accused of, or they weren't accused of anything. Could you tell us a little bit about the added discrimination this type of bill could lead to, on top of what already exists to some extent, some discrimination against the Muslim community?
Madam Mariani, thank you for your question, and that is a real concern in the Muslim and Arab communities since September 11, 2001, since the Anti-Terrorism Act came into play. And we're not discounting the fact that, yes, people are suspicious. There are issues in the world today that might lead a normal human being towards it. That's what we call prejudice and discrimination. We all do it. And the point here is we need to check that. I think we all agree that we want to prevent any harm coming to anyone in Canada from illegal acts of any violence, including terrorism, because it's a mass scale of violence. But to your point, I know in previous testimony, if I can give a bit of a preamble, people have said, well, these powers haven't been used, so how can they be discriminatory? Well, it's not really the hard use. You'll probably see it won't be used a lot. But what we found in the last 10 years is that CSIS, the RCMP, other police agencies, but mostly those two agencies, it's what I call the soft abuse of these powers. They go to vulnerable people, immigrants, refugees. Those are the most vulnerable. But also other Canadians who are Muslim or Arab or maybe seem to be those things. And they're told, you know, we have these new powers, so if you don't cooperate. So it's play ball with me or else I've got this big stick. And, you know, everybody is not schooled in the law. I've been to many mosques and community centers events where, yes, young people, older people, anyone, their computers were taken. CSIS does not have any police powers. They don't have the right to seize property, arrest, search, nothing. You can tell them to go away. I had people telling me their computers, they just handed them over to CSIS because they were told, you need to do this. Yes, they hand
pas leurs droits.
Because they don't know their rights. Many of these people are not even Canadian citizens. They don't know what their rights are. They're afraid of CSIS. That just feels entitled to go into their houses and say, oh, you have a Quran up there. Oh, what does this mean? Are you a jihadi? Listen, I find this so incompetent to base a risk analysis of a person actually taking action and committing terrorism based on these symbols on the wall. Listen, I'm very concerned about CSIS. I've been watching CSIS for a while, and I find this kind of incompetence concerning to me. If we have to count on these people to protect us, will we really be protected? I think the analysis of the terrorism risk based on cultural criteria and not on intelligence is concerning. Am I wrong?
You're correct, and your assessment, I think, before I listen to myself burn my ear around that, I think you're correct, because we're not saying CSIS and the RCMP aren't needed. They're needed to do certain things. As Ms. Chung has pointed out, CSIS has to protect Canada from threats to Canada. Yes, that is their role. But CSIS actually arose from wrongdoing of the RCMP. The MacDonald Commission gave rise to CSIS. The Emergencies Act came out of the misuse of the War Measures Act because we wanted to control when we needed to do things to protect Canada in extreme cases. We have rule of law-based mechanisms to do that. The problem I have with this type of legislation and security certificates and the others is there's not a lot of oversight. The Supreme Court struck down security certificates because there wasn't that oversight. And what happens is the abuse of these powers. And my cart before the horse argument is essentially this, that CSIS and the RCMP, they've got major problems. They need to have a little bit of a think. Go down to the basement and have a little bit of a think. Bring in like a facilitator and work things out before they come out and we give them more powers. Justice Mosley, in the Almarai decision, I invite you to read
very quickly, please.
Some of it's quoted in Craig Forsace's paper. Roundly thrashed them. They don't even understand what jihad is. They made mistakes between a Chechen rebel and Al-Qaeda. Like, they're making fundamental mistakes that all you need to do is read a newspaper or know a little bit about the region. But they don't want to work with the Muslim community in this country, and that's why they don't get it. So while they're chasing red herrings, real terrorists may be getting away.
Thank you, Mr. Mia. We'll now move to Mr. Davies.
Thank you, Mr. Chairman. I have to say a couple of points that seem evident to me from the beginning. One is I'm also concerned about what I perceive to be a circular argument, which is that in order to in order to protect civil liberties, we may have to violate civil liberties. Excuse me, Mr. Chairman, I can't even hear myself.
Can we have some order over here, please? Go ahead, Mr. Davies.
Thank you. So it seems circular, and I also think that we go down a dangerous, slippery slope when we start saying, well, in order to protect our way of life and our civil liberties, I may have to violate civil liberties of other people. The second concept that comes to my mind is the question of the onus. It seems to me that a fundamental feature of the fabric of Canadian society and Western democracies is that we as individuals have certain fundamental rights, and those rights are primary, and the onus is on the state to make a case as to when those rights are properly abrogated. So we even heard mention of the Charter of Rights and Freedoms. Yes, we are given fundamental rights as individuals, and those rights may be abrogated if the state can justify an abrogation of those rights as may be justified in a free and democratic society. So it's not for an individual to justify why they're entitled to their rights. As a matter of being a Canadian citizen, as a matter of fundamental liberty in our concept of democracy, we have those rights until the state justifies otherwise. I want to just talk a little bit about what we're dealing with here. We're dealing with the concept of giving police officers the right to preventatively arrest based on suspicion, and we're talking about compelling testimony from people, forcing people to testify, both of which I think are significant departures from our current legal system. In fact, I'm going to quote the CBA, which says, "These powers, especially the power to conduct an investigative hearing, represent a significant departure from powers traditionally available to investigate criminal offenses." So where I'm going to try to go to is some fact. Because if we're talking about a justification for these powers, I think where we must all start from is the objective evidence. Now, we all know some basic facts, but I think they bear repeating. This is what we know so far, that these powers were introduced in 2001, and in 10 years, they have been used precisely once. Once in a decade. We know that after the original bill sunsetted since 2007, when these powers have not been in power at all, that we have not had any occasion to utilize these powers. We also know that since those provisions were allowed to sunset, that Canadian criminal law has continued to operate effectively. I want to also quote from the Canadian Bar Association submission that we received, and then I'll ask for some comment on this if I can, who said that they said that we must recognize that rules and procedures in Canadian criminal law, as they existed prior to the addition of sections 83.28 and 83.3, were effective for investigating criminal offences, including those associated with terrorism. We must recognize that the rules and procedures in Canadian criminal law, as they existed prior to the inclusion of sections 83.28 and 83.3, were effective in protecting people within Canada from the harm caused by criminal offences, including those associated with terrorism, and CBA has identified themselves as the national voice of the legal profession. So, here's my question. If we put these laws into place, they were used once. We have the Canadian Bar Association, the national voice of the legal profession, telling us that the criminal laws as we had at that time and since are totally effective in preventing us from terrorism. And we also know that standing in distinction to the fact that they were used only once, I can name you 5 cases of serious violations of Canadians' human rights. Mr. Arar, El Madi, El Malki, Nureddin, Chikawi. Can any of you comment on the evidentiary basis, the objective basis that we would, as parliamentarians, possibly have to proceed with a law that so fundamentally alters our Canadian legal system?
I think, and that's the reason for sunset clause, is to, when they expire, to evaluate what is the evidence that you have in terms of what are the dangers that you are trying to seek. And I think it's no coincidence that at the same time as we're doing this exercise, and we should do it thoroughly, looking at the evidence that we have of abuses on one side and the lack of the need, particularly since 2007, that there hasn't been these provisions enforced when they were sunsetted. There have been prosecution for terrorism act that have occurred. So it's not as though the police is unable to act. On the contrary, I think they have been able to act. It's no surprise that now in the UK, the same process of reevaluating whether the strong and the difficult and dangerous tools like control orders ought not to be reevaluated. So the idea of stepping back and saying, you know, this was not necessary, it's no longer necessary, it's not the best way to go, it's better to invest in better intelligence than simply giving more powers, I think may be a better assessment at this stage.
Thank you for your question. I agree with Mr. Rosier, and you know, I don't like prognosticating forward or backward, but if I can use one example, it's, you know, you've been told by the minister and security agencies, RCMP, that they need these new powers. They have a lot of powers, not using those very well. But let's look back 25 years, the real significant terrorist attack that Canadians suffered, but as an Indo-Canadian, I can tell you was not acknowledged for 10 years as a Canadian tragedy, which I find a bit insulting as Indo-Canadian, is the Air India terrorist attack. And would CSIS and the RCMP, let's pretend we can go back in time and give them these powers. Would that have saved those Canadians and others? I don't think so, because let's look at what Justice Major in his findings says. And I'll just give you a couple little snippets that caught my eye. CSIS surveillance was ineffective. Surveillance were unable to distinguish one traditionally attired Sikh from another.
Quickly,
CSIS
Mr. Mia.
failed to provide important information. RCMP wasted resources. Specific threat was not understood. Lack of cooperation between RCMP, CSIS. RCMP failed, and failed.
Thank you.
So at the end of the day,
thank you, Mr.
that's the
Mia.
problem,
Thank
not
you.
new powers.
I'm sorry, Mr. Vernon. I'm going to have to cut it off there. Mr. Rathgaber, please.
Thank you, Mr. Chair, and thank you to all the witnesses for your attendance today and for your interest and concern in this very important and sometimes difficult topic. To Mr. Mia, would you agree that with Mr. Vernon's statement and a statement that's been said by others that the first duty of the state is to protect the safety and ensure the security of its citizens?
I don't think it's an either-or situation. I think that's a bundle of things as the state has to do. Protect. I mean, if all that the state has to do is protect your security, well, you could take away all rights and we'd be pretty secure. But I don't think that's the society we live in. So I think the real issue is the state needs to provide security to its citizens to enjoy liberty. Security is the fundamental basis for the things we take as valuable things: liberty, freedom, the right to come and do these things without fearing that we're going to be persecuted.
Okay, well, you will agree that without safety and security, there is no enjoyment of life, liberty, security of the person, pursuit of happiness, anything, without safety and security.
That's a foundational thing, but I don't want to walk into the baby bathwater thing, that we throw out the baby with the bathwater, trying to keep us so secure. I mean, you can have total security states where we give up all our rights. We'll be physically very secure. But I think in a democracy such as ours, we decide to take some risks in society. Yes, we all agree to take some risks. Otherwise, we just have police stopping everyone on the street and making sure they're not criminals. We tolerate some amount of risk in society. I mean, that is the nature of living in a world. Like, this building could collapse tomorrow because engineers have there's a probability of risk. We built it to 98%, but not 100 because you couldn't do that. That's just the nature of life.
Are you or any members of the panel aware that on January 20th of this year, an individual was arrested in my city, the city of Edmonton, wanted by U.S. authorities based on terrorist charges and murder based on actions that allegedly occurred in Afghanistan?
I don't know the details of it, but I'm generally familiar. I heard it on the news.
Is anybody else aware of that situation? Okay. Now, with respect to this concept of preventative arrest, and I'm troubled by a number of your comments, Mr. Mian, and also you, Ms. Chung. You state with this proposed legislation, C-17, that the legislation is firstly not necessary and secondly open to abuse. And you cite correctly a number of criminal code provisions that deal with charges that can be laid for conspiracy and for attempts. But you'll have to agree with me that those existing provisions of the criminal code deal specifically with issues and allegations that have occurred in the past tense.
No.
You don't agree with that?
I don't agree with that.
You believe that the existing provisions of the criminal code will allow the law authorities, be it the RCMP or CSIS, to detain an individual based on information regarding something that might occur in the future?
Yes, if someone's in preparation of a criminal offense, if I'm in a conspiracy with someone to blow up Parliament, and the police have information of that, they don't have to wait for me to blow Parliament up. That is essentially the criminal law 101.
Now, with respect to the abuse issue, this legislation, or essentially the same legislation, was brought in by a different government after the tragic events of 9/11, and we've talked about that legislation, and it was only used once and sort of in a different circumstance regarding the Air India inquiry. So you'll have to agree with me that this type of legislation, at least historically, has not been abused by Canadian law enforcement.
I don't agree that it's not been. I'll agree with you that it's been used once. Yes, that's a fact, and the Supreme Court so ruled on that case. I wouldn't agree with you that it's not being abused.
Well, if it had to have been abused, I would have thought that there would have been multiple deployments of this legislation, and tens, if not hundreds, of individuals would have been detained and brought upon judges to provide information on what they may or may not know. But that didn't happen.
As I mentioned in response, I believe, to Ms. Mariani's question, it's the soft abuse. I mean, the goal is not to scoop up all sorts of people, although that is a risk, and we're concerned about that. The real risk is this insidious nature that these powers, and we've seen it. I mean, our organization, the International Civil Liberties Monitoring Group, CARECAN, other civil liberties groups, have heard from the community. I've heard it myself. I have a colleague who's a lawyer who works with community members who get calls by CSIS, the RCMP, and not every single officer or agent does this, but we have heard that it's used. It says, you know, if you don't work with me, especially with vulnerable people who are refugees or migrants, you know.
But you're not talking about the former C-36. You're talking about other tactics.
I'm talking about C-36, sir, and security certificates.
C-36 has not been in law since it was sunsetted.
10 years. C-36 has been, the only two provisions, sir, that sunsetted are these two provisions. C-36 is a whack of legislation. I have concerns about that. And C-36 implemented inchoate offenses, a whole lot of those, facilitation, enabling, participation. These are offenses that are very far removed from participation or actual criminal activity. So if you're talking about preparatory offenses, as you mentioned, and I agree with you, we need to catch people when they're preparing something and prevent harm. You could, how do you think the Toronto 18, facilitation, participation in a terrorist group combined with a conspiracy to commit a criminal act, those are all there. They're still in the law. Those provisions from the Anti-Terrorism Act are in the criminal code right now. I have them here if you want to look at them. So these two are the excessive provisions that even the government of the day recognized that they were so exceptional that they needed to be subject to a sunset. But if we keep renewing it, knee-jerk and ad hoc, we have a permanent situation.
Mr. Vernon, you no doubt are watching with great interest the events as they unfold in Egypt.
Yes, of course.
We all hope that the transition of the current regime is peaceful and it leads to a better regime that has respect for democratic rights of its citizenships. But I guess we all fear that that may not be the case. Is that correct?
So I have a point of order as well. I mean, we're studying C-17, the Anti-Terrorism Act. How is a question on the political internal events in Egypt relevant to this issue
I
here?
gave Madam Morani some latitude. Mr. Rath gave it to you. Bring this thing back as soon as you can.
I'm almost out of time, but I guess I'm just curious what you believe the risks are for Canadians and for your community within Canada if events unfold in Egypt, perhaps as they did in say, Iran a couple of decades ago.
Well, the fundamental thing that we're concerned about, I mean, aside from the possible risks to the safety and security of the State of Israel, is the development of rogue regimes that are in thrall to Iran. We've seen the results of that through their proxies in that region. and through their state sponsorship of terrorism, both in the Middle East but also internationally. Let's not forget that the bombing of the Jewish Community Center in Buenos Aires in the 1990s has been directly placed at the footsteps of Hezbollah, acting on behalf of Iran. So the threats to our community and to all Canadians is of unstable regimes that are committed to systems that are antithetical to our way of life.
Thank you, Mr. Vernon. Thank you, Mr. Rathgaber. Your time is up. We'll now move back to Mr. Kenyon, please.
Thank you, Mr. Chair. I will agree with Mr. Rathgaber, and I will say that I think one of the primary functions of the national government is to protect its citizens. But I think what we're doing here is trying to examine whether or not this legislation is necessary to do that, and whether it's necessary to impinge on civil liberties to make that work within Canada. After 9/11, I understand fully why this was passed, but we've had the benefit of experience. And in fact, in terms of the sunset provisions, we've not actually had them since February of 2007 when they expired. So my question to everyone is, since we've not had them since February of 2007, how have we as Canadians suffered in any way by not having them? That's my first question.
Well, the absence of this authority for the last 3 or 4 years doesn't mean that it's not something that the security and police forces should have. You could easily make the argument that...
But I'm not, sorry, I only have 5 minutes. I don't want to theorize. I'm asking if you're aware of how we have suffered since we've not had them since February 7. How have we suffered, if you're aware of any way?
I think the thing to keep in mind is that these powers are necessary to interdict activity before it happens. There are, as it's been stated, powers that do permit that, but these powers, I think, will provide extra authority to make sure that these kinds of activities don't happen. I mean, we've talked about the failures of the security forces with respect to certain individuals.
Because I asked.
But just let me finish my thought.
Finish his answer, please.
I would not want to sit here and say that these powers are not necessary and look back later on a catastrophic security failure because of the absence of these powers that led to the blowing up of a synagogue or a Jewish day school full of children.
Mr. Vernon, thank you for your theory, but my question was, are you aware of any examples of how we as Canadians have suffered because we've not had these provisions in place since February of 2007? I'm not asking you to theorize about how maybe some point in the future, hypothetically, we might need them. I'm asking you whether you're aware of any specific examples where we would have needed them since they expired.
No, but the fact is that
Mr. Chair, I'm going to go to the other people because I have the answer.
These authorities, these powers have been on the books.
Mr. Vernon, I have other people that I need to have the question answered. Knows the answer. Thank you. Anybody else?
We are unaware of any specific examples. I understand that this committee has not heard of any specific examples either.
Anybody else?
I think we should mention also that there are some successful prosecution of terrorism before it occurred in the Toronto 18, for example. So I think we have the evidence on the other side.
Okay. And in terms of our criminal code or other legislation, are you aware, Madam Chung, Mr. Mia, of any reason why that legislation would not be sufficient to protect the Canadians under these circumstances? Because for me, the issue, once again, I agree with Mr. Rathgaber, it is our job to protect Canadians, and so one of the highest things that we must do. But the issue is whether the current legislation is sufficient to do that, or whether we need to have legislation in place that does impinge on civil liberties. And we now have the benefit of experience. This was passed years ago. We've had sunset provisions that expired in February of 2007, so we haven't had this legislation for a few years. So once again, now that we have this wealth of experience, do we need more? And that's the question, as opposed to what we currently have under our law.
Mr. Mia, please.
And I don't want to play the game of what ifs, as Mr. Vernon, like, we can imagine a number of scenarios and we'll come up with a giant book of laws to prevent every possible scenario of what ifs. But let's look at the facts, as you've mentioned. The Toronto 18, Mr. Kawaja, and just recently a number of others. We didn't use any of these extraordinary powers, even though we had them. Why not? Because we used the criminal code. And by doing that, they get a fair trial, so we know what we're getting in evidence and in cross-examination, and the adversarial process is right and correct, and we convicted the right people. And it's an open process that creates confidence in the public and does not compromise the role of the judiciary and a host of other things. I mean, this legislation, if you're going to pass it, I have a number of amendments I think you should make, imminence and others, a 2-year sunset clause, not 5 years. I don't want to go there. I'll talk to you about those if you want to. Implement what the Supreme Court had said. So there's a lot of work still to be done on this. But I don't think we need them. As I mentioned, there are all those other provisions, facilitation, participation, enabling. And those were used, and used successfully, and it didn't erode our rule of law traditions and confidence in the system.
Thank you very much, Mr. Ganya. We will now move to Mr. Norlock, please.
Well, thank you very much to the witnesses for attending, and I guess I'll start off by saying I usually ask my questions and direct my comments to the men and women who will be at home, and especially the young people who are at home watching the proceedings today, and to remind them that most of the people in this room, most of the people around this table have already made up their minds just by their statements as to whether or not this kind of legislation should or should not be enacted. But many of the folks at home have not made up their minds, and they are listening to us trying to make those decisions.
Excuse me, Mr. Chairman, I just have I'm just asking, are we televised?
Yes, we are.
Yes, we are.
We are. Thank
I'm
you.
saying that
Okay.
specifically because...
Well, it doesn't say that on the notice. I decided
it does on mine,
Does
sir.
it?
No,
Thank you.
continue.
I hope that wasn't taken from my time.
No, we'll give you an
going
extra
across.
minute.
Thank you. 30 seconds would be more
Go
than
ahead,
enough.
Mr.
We could
I
time it.
apologize, Mr. Norlock.
No, that's okay. I appreciate it. So that's basically why it is. So I've just made a few notes, and I think they're important because, as I say, I don't think any of our witnesses here are being disrespectful or anything else. These are their true feelings and their true views. And these are some of the thoughts that I put down on paper that were mentioned. Who are the real terrorists? And I guess my question would be to the average Canadian: who are the real terrorists? Well, we do know that there have been prosecution of terrorists. One of the greatest terrorist acts that this country has suffered is the Air India. So I have to say that the terrorists don't belong to any one group of people from any one religion. They're right across the board, and they exist around the world in every way, shape, or form. Then we hear, of course, that from more than one witness and more than one political party at the table, that CSIS is dysfunctional and the RCMP have huge troubles, et cetera, et cetera. And I think we all have a responsibility to, if we say those things, say, are these agencies capable of making Canadians safe? And I would say the evidence that they are capable and they have kept us safe is the fact that we have not had the kind of terrible terrorist acts that they have had in Great Britain, the United States, and many countries throughout the world, and it's because of these agencies that we are safe. Have they made mistakes? Of course they have, because they're made up of men and women who are human. They make mistakes, and no one agency or group of people, whether they be learned judges, would ever say that they are not capable of making errors and judgments and mistakes. And I think Canadians need to know, why do we have an Anti-Terrorism Act in these laws? We have it, as it was mentioned, because the United Nations directed all of its members to look at their laws and regulations to ensure that they are made in such a way that they can prevent or attempt to prevent terrorist acts like 9/11, but not just restricted to that one act. And that Canada took on that obligation and constructed the Anti-Terrorism Act under a previous government that this party, and I think all parties, I forget how the votes were, but that the two major parties in Canada agreed with. But because we were unsure, and because there were some significant changes to our law, we put a sunset clause in. We revisited that. I was part of the subcommittee on anti-terrorism, and I can tell you we looked at it, we had a wholesome debate, and it was the majority view that we should maintain, with a sunset clause, these provisions. The comment we were talking about the Toronto 18. The comment that the police have not used, the police and other authorities have not used these existing provisions are evidence, I would suggest to you, to the fact that the police are very much aware, and CSIS and those other authorities are very much aware that you only use these provisions when the criminal code may not apply, but that there is sufficient evidence to believe, or to have you believe, that you need to prevent an occurrence, that you need the benefits of C-17. And I go further to say that their authority is extremely restricted, because they may only hold a person for 24 hours, and that's if a judge is not available. And if a judge is available, we constrain that judge by saying you may not detain more than 72 hours. So my comment is that we need this legislation, because it does indeed add a measure of safety to every man, woman, and child in this country.
Mr. Norlock, we'll now move back to Madame Morani.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. My question is for Ms. Desrosiers and then Mr. Vernon. Ms. Desrosiers, you were saying earlier that it was important not to abuse these exceptional powers that everyone here is referring to, except for Mr. Vernon, perhaps. But it might be not be the first time we've discussed this, but CSIS has recognized that it has used intelligence collected through torture, and I think any information gathered as a result of torture is non-reliable. Why? Because people are prepared to do anything to escape torture and pain. If we say we're basing a risk analysis on information obtained through torture, on ethnic criteria, on everything we see in the newspapers or internationally, what we see in the media or on the net, because that's how they're doing their work, and on investigations, where they go to, the average person and ask questions, again, based on ethnic criteria. And here, I'm not calling into question the RCMP, because, in fact, I think the RCMP is doing better work than CSIS, because they are required to do real investigations, wiretapping and the rest. Do you think this kind of agency, with those types of powers, may, in the end, not only abuse its powers, and if perhaps it might be, we might be targeting the wrong target. Essentially, we should focus on the entire agency and its way of operating, so that we may get information based on facts and not on ethnic criteria or biased information obtained through torture. Do you not think that perhaps the work we need to do is rather not to extend this legislation, but really go to the issue of CSIS and make it an agency that performs on the world level? The perspective of our association is that there certainly is a great deal of work that needs to be done to ensure accountability. I think it's been said, and reports have shown systematically that there are suggestions for improvement, and there are two ways to improve things, two ways to look at it. First of all, it's important not to forget about the reports as a result of public inquiries. Make sure that these results are implemented, these recommendations, so that Canadians can get value for money. These public investigations were held, and there are some specific recommendations as to how to improve techniques, investigative techniques, and powers granted to the association. And of course, our Civil Liberties Association believes it is absolutely essential to implement these recommendations. Mr. Vernon, you were saying earlier on that you're in favor of this legislation. You consider that these powers, these exceptional powers, should be granted, even if it means we should somewhat set aside individual rights. Is that correct? I'm not mistaken, am I? You're right. When you look at countries like England, Spain, France, Russia, and the U.S., they have very serious anti-terrorism legislation, very controlling, which might even set aside individual freedoms, and yet it has not prevented terrorist attacks from occurring. In fact, I went to a jail in England, Whitemoor, and when I asked the director there who the clientele was, if you will, it was 60 or 70% Muslim. The entire penitentiary was filled with presumed terrorists or people who had committed terrorist crimes. It's a huge jail. Do you not think it makes just simply no sense to create legislation that are useless? They're useless because there are still terrorist attacks, and we're just filling up these jails with these presumed terrorists, and in the end it doesn't change a thing. Do you think the solution is not elsewhere? Perhaps, yes, we need legislation, but that respects the rights of individuals and strikes that balance. Perhaps there are other solutions that we could address. What would be the other solutions?
Unfortunately, we'll have to get that question in with another one because you're well over 5 minutes. We'll now move to Mr. Lobb.
Thank you, Mr. Chair, and I'd like to thank the guests for appearing here this morning before our committee and addressing the serious legislation. One thing that caught my eye, or caught my ear, in Mr. Mia's testimony was that he said that laws shouldn't be put in place or laws shouldn't be made on the basis of fear. I'm probably paraphrasing a little bit with that, but yet some of the testimony today that we've heard from Madame Desrosiers and Mr. Mia actually are presenting fear. They're slamming the RCMP. They're slamming CSIS. They're bringing their activities into question. They're talking about setting precedent in Canada that will set a precedent for international law. And in my mind, they're as much talking about fear and, slightly twisting the facts as anything. And I think it's unfortunate because, like I always say, it's not easy being a police officer. It's tough work. And the RCMP and CSIS, they come to work every single day, and they do a good job. And they try hard, and we see them every day on the Hill here, and they do a darn good job. My point and my question to Mr. Vernon is on the fact of investigative hearings. And there's other countries that have investigative hearings. This isn't just a new concept for Canada. England has investigative hearings. Australia has investigative hearings. The United States has investigative hearings. So my question is, and for the people at home that are watching, if a person refuses to answer a question, they have the ability under investigative hearings, correct?
Yes.
That's correct. And in fact, in 2004, there was a Supreme Court ruling that actually recognized the constitutionality of investigative hearings. Is that correct?
Either it's charter-proof or it's not. You can't be a little bit pregnant. It's been proven to be charter-proof, yes.
So, we have people here today, some of our witnesses here today, questioning the constitutionality of it. They're questioning some of our most sacred institutions like the RCMP and CSIS and referring to the courts, yet when the Supreme Court rules the constitutionality of investigative hearings, they're still not satisfied with that.
Can I just make one
yes,
comment on that? And it goes back to something that Mr. Norlock said as well. The attacks on CSIS and the RCMP here are, I think, unfounded in the way they connect into dealing with this legislation. We would be led to believe that it's get smart and Dudley do right. The fact is, as Mr. Norlock pointed out, we haven't had a major serious terrorist attack, but it's not for lack of trying. CSIS has clearly indicated that there is vigorous, robust terrorist activity going on in Canada by cells and groups that are fundraising, organizing, contributing to the training of terrorists right here in Canada. And the experience that the Jewish community has had with both CSIS and the RCMP with respect to the security of our community has been nothing but exemplary. They've been diligent and professional in dealing with us, in understanding the seriousness of threats, and in making sure that our community is safe.
And I have a little bit of time left, Mr. Chair.
You have 2 minutes.
Okay. Mr. Vernon, another question I want to bring to your attention. Under proposed section 8328, it talks about if a person or an individual during an investigative hearing does produce some information or produce some testimony, that actually cannot be used against them. The only thing that can be used against them is if they in fact lie during the investigative hearing, or the other point is give contradictory evidence. Would you agree?
Yes, and I think that again the overall issue is this minimal impairment of civil rights sufficient to throw away the value that we might get from the RCMP and CSIS having these powers. Yes, they haven't been used extensively in the time that they've been around. Yes, we haven't had them since the sunset set on them. But that doesn't mean that these powers aren't important and that they could be used very effectively in the future to prevent a catastrophic failure of intelligence.
And just to set Canadians' minds at ease, if this were to be in fact used, federal and provincial attorneys generals will produce an annual report every year indicating and explaining to Canadians where an investigative hearing was used. Do you agree with that, and do you think that's a good practice to put in place?
It's excellent to have that in place. There needs to be some transparency in this, but of course we're dealing with intelligence matters where public information can be extremely detrimental. But that doesn't mean that we're developing a scenario here where these investigations are the star chamber. Again, the point that Mr. Rathgeber made about fear, or perhaps it was you, I'm sorry, made about fear. We should not be alarming Canadians about the potential consequences of these actions. I think we should be telling Canadians that we have a very serious issue here. We have serious and real credible threats against our security, and we need to make sure that our police and security forces have all of the authority and powers that they need to make sure that this doesn't happen.
Thank you, Mr. Vernon. Mr. Holland. Oh, I'm sorry, Madam Mendez.
Merci beaucoup, Monsieur le Président. Merci.
Thank you very much, Mr. Chairman. Thank you to the witnesses. I'd like to get back to Mr. Vernon's last sentence that we should not alarm Canadians about any impairment of their rights. In fact, I would say that we shouldn't alarm Canadians about the potential for terrorism. We have not here in Canada experienced terrorist activity that is so intense that it would justify abusing rights. I'd like to hear what you have to say, Mr. Mia, Ms. Chung, and Ms. Desrosiers, about the issue of the Toronto 18. Something that is relatively recent in our minds. And in this case, none of the provisions provided under this bill were used, and yet we were able to thwart this terrorist conspiracy. So at the RCMP and at CSIS, we do have very competent people there, people who can do their work without using these exceptional powers, who managed to thwart this terrorist plot, ensured Canadian security and safety, and we did not need to use these extreme measures that are an impairment of our basic civil rights.
Mendez.
Je pense que il est
clearly, it is far better for Canadian society that powers under the criminal code be used, that they be used wisely, to start because police officers know these powers well. They know how to use them. The system knows them. The guarantees work well. Within that context, there are mistakes. We know mistakes have been made and others will be made. But at least the system works within a certain context, and there are enough guarantees there to produce good results. It's reassuring for Canadians to know that the evidence was there and that these people were found guilty on the basis of sufficient evidence. And that is why, and that in essence is a better approach. in terms of protecting human rights, and also we want to make sure we're targeting the right people. It's useless to incarcerate the wrong people and detain the wrong people. The idea of protecting the presumption of innocence is not simply to protect the rights of those that are incarcerated, but also to protect the public interest so that we really find the right individuals here and not the wrong ones.
If I could just add, there's a wonderful Latin phrase, post hoc ergo propter hoc, and it means that just because something happened doesn't mean it had to happen that way. With the Toronto 18, we got very lucky. That was a conspiracy waiting to be discovered. The next
they were
group,
very professional.
The next group may
They
be
did their job.
Who did?
Our security forces.
Exactly,
They did
because
their job.
but that's right.
We weren't lucky.
No, but we were lucky that they didn't need to use those powers. The next group might very well be much more sophisticated and much more difficult to penetrate, and I wouldn't want our authorities not to have these powers to deal with them.
Mr. Ian, Madam Chung, yes,
The only thing I would add to my colleague, Mr. Rosier, is that the Toronto 18 prosecution was a very good example of disrupting a future terrorist attack. And so it doesn't go to only prosecuting acts of terrorism that have already occurred, but preventing future attacks.
Mr. Vernon, I mean, if we prepare for every what-if scenario, we won't have much left, and we'll have laws as high as a quarter horse. We don't design laws that way. We use logic and the rule of law. But, Madam Mendez, yes, CSIS and the RCMP worked well, and local police forces in the GTA. Toronto 18 was done well. I'm not saying they're always making mistakes, and I don't want to be characterizing them as that. But what we need to do is we know, and it's not, Madame de Rosier and I are not peddlers of fear. That is incorrect. We're telling you what the Aurora Commission said, what the Air India Commission said, what Justice Mosley said in Almarai, that there are serious problems here. And to respect our agencies, we need to just be honest that there are serious problems. And for all the mums and dads watching out there in TV land, when your kid does something wrong, you don't just cover it up. You tell them, let's correct this so you'll be better at what you do. We need to always have continuous improvement. You all have an ombudsman and oversight. I do as a legal professional. We need oversight of these agencies to make them do their jobs better.
Thank you very much, Mr. Mia. We'll now move to Mr. McColman.
Thank you, Chair, and I would like to thank the witnesses for being here, and also point out, as Mr. Vernon alluded to in his opening comments, he had short notice. We actually had two family members of victims scheduled today to testify here. Unfortunately, they both have the flu and couldn't make it, but we certainly appreciate you being here, and I just think it's good to get on the record that that your presence here today is not significant. It's very significant. I don't mean to diminish that, but we are concerned with listening to the victims of terrorism and actually getting their views on this issue too, and hopefully that can happen down the road. Now, as I listen to the discussion today, it's quite apparent that our law enforcement has taken a major hit from those who wish not to have this bill go forward. And I too want to just underscore my colleagues' comments that these are human beings, men and women. They do make mistakes from time to time, but on balance, and in the scheme of our national security, they do a fine job. And thank goodness we're a country that has not had to experience a terrorist attack such as a lot of other Western democracies have, and their way of life have been brought forward. Now, as I look at terrorist organizations and the reason we need to give law enforcement the tools that this bill contemplates is they survive like Al-Qaeda and the like survive because on two major resources, money and personnel. So it's like any major organization. They have to have money, and they have to have recruits, and they have to have training grounds for those recruits, and those recruits are taken and are preparing for something, whether you think it's a terrorist attack or just to engage in a debate like we are today, is you can judge for yourself. Having said that, one of the reasons why we've had testimony before and why this is appropriate to go forward with this is the fact that we need to stop terrorism in its tracks by finding the money trail. We need to find and get those people who are suspected of fundraising in our country and other countries around the world, and we need to have the law enforcement to have the tools, all the tools available, not just partial tools, but all the tools available at their disposal to disrupt that. That's for sure. And this is another tool. We had testimony from an earlier on December the 15th from Professor Forsese of the University of Ottawa, and he has done an extensive study of this legislation and compared it to other countries. And I won't go into the details because you probably all know the details. But countries like the UK and Australia have far more stringent, extreme holding powers in this. In there's laws that are similar to this. And he identifies a gap in our system in his testimony here. He says there is a gap. And so when asked of him and the department officials who drafted the laws in previous testimony, we asked what were they attempting to do? Were they trying to close that gap? And trying to do it with a balanced approach to human rights, as we've said, which are far less stringent and rigorous than other countries. And that's exactly what they're doing, is trying to close that gap. And so really, and just one more point. I may not get a question in here because of time. The other thing that's misleading here today in terms of certain questioning and testimony that's given is actually CSIS is overseen by a civilian board. But one of my colleagues from across the table was indicating that they're not, that they need some kind of civilian oversight. But they are overseen by an arm's length from government civilian board, and that's called SERC, the acronym SERC, Security Intelligence Review Committee. So I want to point that out. And I'd like Mr. Vernon to respond just to the comments that I've made. We as a country are taking a far, what I will call a lesser approach to the stringentness, or the, I don't know the word to use here, but the conditions of this going forward compared to other countries. What are your views on that?
Actually, it would be interesting to hear your views, but we are out of time. Thank you. We'll now move to Mr. Holland, please.
Well, perhaps I could start just by continuing on what Mr. Forsey said. Mr. Forsey went on to say, quote, "I'm not sure that Bill C-17 is useful in filling that gap." That's the gap you were referring to earlier, Mr. McColman. He continued, "I'd be unprepared to have those extra aggressive provisions imposed via this legislation in the absence of robust checks and balances to enhance the civil liberties." So he went on to say actually he doesn't agree and certainly wouldn't proceed without the addition of extra checks and balances. Let me come back because a comment has been made several times, you know, sort of saying we appreciate and we like, you know, the work that is done by the men and women who are police officers and CSIS officers. Let's agree that everybody around this table, both witnesses and politicians, all deeply and profoundly respects the job that is done by men and women who serve this country. That's a given, and I think everybody would agree with that. What is that question is in any society, in any human society, there are errors, there are flaws, there are weaknesses, and that's why we need oversight. And I think we've all seen examples where when we erode that, when we let it go, that it leads to bad and dark places. And that's the point here. And so if I could, to the witnesses, on that issue of oversight, how imperative is it that we fix what's broken first at a very minimum before extending those additional extraordinary powers?
Mr. Holland. Madam Chung.
I'll be brief. I think we all want to speak on this subject. I think it's imperative that we have proper oversight. And of course, we appreciate that there is a civilian oversight of our CSIS in the form of SERC, but I think the recommendations that have been made by previous inquiries is that there be cross-agency oversight on security, issues of national security, simply because of the nature of those investigations and how national security investigations are undertaken. And so it's absolutely crucial that we have those mechanisms in place prior to expanding on already very broad powers of investigating terrorism and terrorism-related offenses.
Mr. Mia, and then Mr. Vernon.
Thank you. First of all, I just want to correct any misunderstanding. And I think CSIS and the RCMP are doing a relatively good job in most cases, and that they're needed to some extent within the bounds of the law that created those entities. But exactly what Mr. Holland, I've been reiterating, is the oversight. And my organization has been calling for cross-agency national security oversight of all agencies, because after 9/11 everything was integrated, sharing information, and you had like a toothless complaints commission at the RCMP, CERC, and others. Bring it all together. If we're going to integrate national security, we need integrated oversight and accountability. I mean, the Arar Commission pointed out significant mistakes. As human beings, we make mistakes, and that's why we need checks and balances. We paid Mr. Arar some money, and I think that's right, because we harmed his interests and his liberty, and he was tortured because of things that our agencies did. At the end of the day, what we really need to do is look at Arar. Nothing's been done on that. No one that was identified that did things that gave rise to Mr. Arar's plight has suffered. Many of them have been promoted in the RCMP. So I think that's the kind of thing we need to think about. Let's fix this first. This legislation can't even go forward as it is. It needs fixing itself, and I believe Mr. Forsese has mentioned things. Others have mentioned things that need to be fixed. But first, start with the oversight, fix the agencies so they work for us, and then see if we need new powers.
Thank you, Mr. Mia. Mr. Vernon.
Thank you very much, Mr. Chair. First of all, I'm not clear how we can talk about the erosion of our civil liberties when in the past 10 years there's been zero evidence of that with respect to these two provisions. So I'm not clear that we're in that kind of crisis mode. Having said that, we believe that the checks and balances are good in this bill. If there are others that can be proposed, we'd be prepared to look at it. From the larger perspective of oversight, we've been supportive of expanding the role of Parliament in reviewing and having that kind of oversight authority over the security apparatus writ large. If there could possibly have an officer of Parliament established to look into that and make sure that all elements of the counterterrorism regime are being implemented effectively and properly. You could have a subcommittee of this committee focusing on that. There are methods and modalities that can be investigated to enhance oversight. But that doesn't mean that these powers need to be thrown out.
Thank you, Mr. Vernon. Madam Morani.
Merci, Monsieur le Président.
Thank you, Mr. Chairman. Mr. Vernon, do you have a solution that is other than legislation that you could propose?
There are numerous discussions in countries like Canada and the UK with regard to what 21st century multiculturalism looks like. I think that there are certain elements of how we approach diversity within our communities, how we promote integration and the notion of maintaining one's identity while adhering to an overarching set of core national values. I think these are aspects of how we conduct ourselves here as Canadians that could certainly be looked at in order to deal with the issue of second-generation radicalization. I think we have to look into these situations and ask ourselves why there are elements within certain communities that don't seem to have the attachment to Canada that perhaps their ancestors did when they arrived here. So there are these kinds of socioeconomic components of the situation that need to be looked at. But at heart, terrorism is a criminal act, and we need the authority and the power to interdict it, and then unfortunately, if something happens, to make sure that the perpetrators are caught and punished.
Mais pensez-vous aussi qu'il faudrait un peu plus de...
But would you not also say that there needs to be more justice on a global scale in terms of conflicts, so as to allow the resolution of some conflicts throughout the world, for instance, in the Middle East?
I think it's a bit of a red herring to suggest that lack of justice is at the heart of terrorism. If you take a look at the people that are involved, certainly with the 9/11 attacks, these were not people coming out of abject poverty. Certainly, we're all in favor of justice and the promotion of human rights for all peoples. But I don't think that this notion of root causes for terrorism can take away the fact that there are people out there with evil agendas. And we need the powers to make sure, first of all, that number one, that they're put out of business altogether, because these are people who are associated with values that are completely antithetical to our way of life, but certainly to make sure that we here in Canada are protected from the ravages of these attacks.
Est-ce que vous pensez, Monsieur Vernon?
Mr. Vernon, do you believe that torture is a good thing? Are you in favor of torture?
One certainly can't be in favor of torture.
Et pensez-vous que...
And do you believe that an agency like CSIS is entitled to use torture to obtain information through torture? Or any other agency, for that matter? Very well. The fact that CSIS recognized it used information obtained through torture, would this be a sign of competence?
I wouldn't say that it was a sign of competence or incompetence. I would say that it was a sign that perhaps there were some individuals who exceeded their mandate, or perhaps were overzealous in pursuit of important intelligence.
Relativement à l'affaire Omar Khadr.
Regarding the Omar Khadr issue, that you might have seen some videos of some of the examinations of Mr. Khadr, the young man or boy, the crimes that he's accused of in Guantanamo. Did you find that the attitude of CSIS agents in that case was acceptable?
With great respect, I'm not sure that my attitude toward what they did is particularly relevant here. I think there's a huge gap between the kind of intel that's gathered through torture and the kind of intelligence that's proposed to be gathered through these two measures that are part of the bill today. There's a lot of daylight between that, and I think it does us a disservice to lump all of that together under the category of...
Avez-vous une opinion là-dessus?
Do you have an opinion on that? That's your opinion. It's your opinion that I'm asking for. When you saw these videos of examinations of that minor.
Madam Morani, go ahead, Mr. Vernon.
My opinion is that it's unfortunate what happened to him, but I suppose that there are situations where these things will happen, and we have to do what we can to make sure that these sorts of activities aren't repeated. That said, he's been accused of some very serious charges, and we need to let the justice system work its way through.
Thank you very much. I want to thank all witnesses today for appearing before our committee on this very important piece of legislation, and certainly your input is appreciated here today. Seeing our time is up, we are now adjourned.